Many in California dream of exercising their right of self-defense protected by the Second Amendment to the Constitution of the United States. That's because today they are living in a nightmare of laws and regulations designed to prevent otherwise law-abiding citizens from exercising their right to keep and bear arms. The recent case of Miller versus Bonta may sound like a blow for freedom in the Golden State. The opinion itself, however, is more of a good news, bad news situation. So we'll discuss that next on the Constitution Study.
Came from a long through line of everyday Americans.
Hello there, everyday Americans. Welcome to the Constitution Study. This is where we read and study the Constitution. We teach the rising generation to be free. Today, we're looking at a court case out of California. But before we do that, please, if you want to find out more, head to the website constitutionstudy.com. That's where you'll find everything we're doing here at the Constitution Study. We've got books and articles and videos all there for you to share, for you to enjoy, and for you to help teach not just the rising generation, but your friends and neighbors. And if you want more, you can find out there. We're doing a tour. I'll talk a little bit more about that at the end and some other things I've got going on. But please, that's a great place to find this video along with the associated articles and other material for your education, your edification, and sharing with others. And I really ask that you do that. And if you're listening to this on the podcast, if you go to Apple Podcasts, give me a rating review. Help me move up the charts so that other people can find this. I would appreciate that greatly. Now with that, let's talk about what's going on with the right to keep and bear arms in California. The government of California, like a few other states in the Union, appears to have it out for law-abiding gun owners. Among the myriad of unconstitutional and therefore illegal laws in that state was a ban on certain firearms based on features. These so-called assault weapons, a term of nebulous definition at best, are led by the often vilified AR-15. I've even heard it described as the Assault Rifle 15, although AR is actually an abbreviation for Armalite Rifle, after the company that developed the original design. California's assault weapon ban was challenged by a group of citizens and was recently heard by Judge Robert Benitez of the Southern District of California. Now, while reading the court opinion is not something most of us would do for fun, I recommend anyone interested in the Second Amendment actually read this one. It is chock full of quotes and statistics that those who support our right to keep and bear arms will find quite useful. While Judge Benitez did conclude that California's assault weapons ban was unconstitutional, the argument he used for that conclusion leaves it open to being overturned on the simple whim of another court. The opinion opens with the following statement, quote, "Like the Swiss Army knife, the popular AR-15 rifle is a perfect combination of home defense weapon and homeland defense equipment. Good for both home and battle, the AR-15 is a kind of versatile gun that lies at the intersection of the kinds of firearms protected under District of Columbia versus Heller, yet the state of California makes it a crime to have an AR-15 type rifle. Therefore, this court declares the California statutes to be unconstitutional." I like the analogy of the AR-15 to a Swiss Army knife. Useful, flexible, and with options galore, the AR-15 style rifle, what the court refers to as a modern rifle, is easily customizable to almost any user's desire. Therefore, is it the AR-15's versatility that scares so many, or is it the rifle's looks? Well, I've been confronted with many who view the AR-15 as an extremely dangerous weapon. As the Judge Benitez noted, the facts simply do not agree. Quote, "This case is not about extraordinary weapons lying at the outer limits of Second Amendment protection. The banned assault weapons are not bazookas, howitzers, or machine guns. Those arms are dangerous and solely useful for military purposes. Instead, the firearms deemed assault weapons are fairly ordinary, popular modern rifles. This is an average case about average guns used in average ways for average purposes." While how dangerous a bazooka, howitzer, or machine gun may be can be debated, when it comes to the Constitution, it is not how dangerous the weapon is. The only question that should matter is it an arm, as the Second Amendment states? Quote, "A well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed." The Second Amendment to the Constitution says the right of the people to keep and bear arms shall not be infringed. It doesn't say arms except those used for military purposes or those that are deemed too dangerous for civilian use. So how do we define an arm? Well, from Webster's 1828 dictionary, we read, quote, Weapons of offense or armor for defense and protection of the body. In law, arms are anything which a man takes in his hand in anger to strike or assault another. So anything you can take in hand to strike or assault another is an arm. That includes swords, knives, chemical sprays, and yes, handguns, shotguns, rifles, and the beloved AR-15. As a further example of what the court in this case terms modern rifles are not extraordinary weapons, Judge Benitez points out how common they are. Quote, modern rifles are popular. Modern rifles are legal to build, buy, and own under federal law and the laws of 45 states. There are probably more modern rifles in circulation than there are Ford F-150 pickup trucks. In 2018, 909,330 Ford F-150s were sold. Twice as many modern rifles were sold in the same year. Imagine every time one passes a new Ford pickup truck, it is a reminder that 2 new modern rifles have been purchased. That is a lot of modern rifles owned by Americans. Well, Judge Benitez points out that modern rifles are legal to build, buy, and own under federal law and the laws of 45 states. I would point out that they are legal to keep and bear under the Constitution of the United States. The statistics that twice as many modern rifles were sold as Ford F-150 pickup trucks in 2018 should answer the question as to their common usage today. With this statistic in mind, I doubt I will ever look at another F-150 pickup truck the same again. But what is the role of the media and activists on this assault weapons ban? Again, from the opinion, quote, one is to be forgiven if one is persuaded by news media and others that the nation is awash with murderous AR-15 assault rifles. The facts, however, do not support this hyperbole, and facts matter. Federal Bureau of Investigation murder statistics do not track assault rifles, but they do show that killing by knife attack is far more common than murder by any kind of rifle. In California, murder by knife occurs 7 times more often than murder by rifle. For example, according to the FBI statistics for 2019, California saw 252 people murdered with a knife, while 34 were killed with some type of rifle, not necessarily an AR-15. A Californian is 3 times more likely to be murdered by an attacker's bare hands, fists, or feet than by his rifle. In 2018, the statistics were even more lopsided as California saw only 24 murders by some type of rifle. The same pattern can be observed across the nation. I guess those who are pushing assault weapons ban across the nations will soon be pushing for knife bans, similar to those in New York State and the United Kingdom. How long before people are required to register their bare hands, fists, and feet to prevent manual violence? Will people be required to microstamp their knuckles so that law enforcement can read the impressions you leave on the face of your opponent? While these and other quotes from the opinion are wonderful fodder for the effectiveness of varying gun control schemes, they and Judge Benitez miss the point. From the opinion, quote, the Supreme Court clearly holds that the Second Amendment protects guns commonly owned by law-abiding citizens for lawful purposes. At the same time, the Second Amendment confers an individual right to keep and bear arms that have some reasonable relationship to the preservation or efficiency of a well-regulated militia. Starting from the beginning, the Supreme Court does not have the legitimate power to tell the country what the Constitution says or means. That power is not delegated to the United States, much less any of its courts. The Constitution, as written, is the supreme law of the land. Every judge in every state is bound to it. And every judge in every court has sworn or affirmed that they will support it, as Article 6 of the Constitution states, quote, this Constitution and the laws of the United States which shall be made in pursuance thereof, and all treaties made or which shall be made under the authority of the United States, shall be the supreme law of the land, and the judges in every state shall be bound thereby, anything in the Constitution or laws of any state to the contrary notwithstanding. The senators and representatives before mentioned and the members of the several state legislatures and all executive and judicial officers, both of the United States and of the several states, shall be bound by oath or affirmation to support this Constitution, but no religious test shall ever be required as qualification to any office or public trust under the United States. As we've read, the Constitution guarantees that people have the right to keep and bear arms, not, as the Supreme Court said, guns commonly owned by law-abiding citizens, but arms. If it is a weapon for offense or armor for defense, it is an arm, and therefore protected under the Second Amendment. If you can take it in your hand to strike or assault someone, it is an arm, and therefore protected under the Second Amendment. There is no rational reading of the Second Amendment that limits the people's right to keep and bear arms to those that have some reasonable relationship to the preservation or efficiency of a well-regulated militia, as Judge Benitez quoted. And although the Supreme Court cautioned that the Second Amendment does not guarantee a right to keep and bear any weapon whatsoever in any manner whatsoever and for whatever purpose, according to Heller, lower courts have often cited this proviso about extreme cases to justify gun laws in average contexts. The Supreme Court may state that the Second Amendment does not guarantee your right to keep and bear any weapon whatsoever in any manner whatsoever for whatever purpose. However, the Constitution of the United States does say almost exactly that. While you cannot keep and bear arms for any purpose, the Second Amendment says that government shall not infringe on your right to keep and bear arms. That means every arm you want, in any manner you want, for any lawful purpose you want. I guess when it comes to following the Constitution, 2 out of 3 isn't very good at all, is it? So if there is good news and bad news about this decision, what are they? Well, first, the good news. A federal judge has found that California's assault weapons ban is unconstitutional. If this opinion is upheld by higher courts, it could be used to find all state and federal assault weapons bans are repugnant to the Constitution and therefore void. And for those of you who engage in debates about the usefulness of these so-called assault weapons ban, there is plenty of fodder for you to use. Now the bad news. Judge Benitez did not so much find that you have an unalienable right to keep and bear arms, but that the Attorney General of California did not provide a sufficiently compelling government interest in restricting that right when it comes to what California calls assault weapons. As Judge Benitez noted, quote, "You might not know it, but this is a case about what should be a muscular constitutional right and whether a state can force a gun policy choice that impinges on the right with a 30-year-old failed experiment. It should be an easy question to answer. Government is not free to impose its own new policy choices on American citizens where constitutional rights are connected. As Heller explains, the Second Amendment takes certain policy choices and removes them beyond the realm of permissible state action. California may certainly conceive of a policy that a modern rifle is dangerous in the hands of a criminal and that therefore it is good public policy to keep modern rifles out of the hands of every citizen. The Second Amendment stands as a shield from government imposition of that policy." While Judge Benitez claims that the Second Amendment is a shield from government imposition of keeping modern rifles out of the hands of every citizen, notice how he got there. It is not because California has a 30-year policy infringing on the ownership of modern rifles, but because that policy has failed to reduce gun violence. According to Judge Benitez, the Supreme Court in the Heller decision, not the Constitution, has taken that choice out of the realm of state action. Based on this and the Heller opinions, should a state or a federal government impose an assault weapons ban and show evidence that gun violence was reduced, then that policy would be allowed to stand. Even worse, this is the opinion of just one judge. This case has already been appealed to the Ninth Circuit Court of Appeals, not exactly known for its deference to the language of the Constitution. Now, should the Ninth Circuit opinion be appealed to the Supreme Court, there is no guarantee or not even decent odds that the court would actually accept it. In short, we have one judge's opinion to protect the rights of the people of Southern California, a position based not on the Constitution of the United States so much, but on the opinion of the justices of the Supreme Court. As Judge Benitez noted in his opinion, quote, "Prior to 2008, lower court opinions did not acknowledge that the Second Amendment conferred an individual right to own firearms or that the right applied against the states. If courts were wrong prior to 2008, what is to keep them from being wrong in the future?" See, by anchoring his opinion on the drifting tide of judicial opinion rather than the anchor of the language of the Constitution, Judge Benitez has subjected it to the whims and waves of other judges. Even his constitutionally based arguments are full of qualifications. Quote, "There is only one policy enshrined in the Bill of Rights. Guns and ammunition in the hands of criminals, tyrants, and terrorists are dangerous. Guns in the hands of law-abiding, responsible citizens are better. To give full life to the core right of self-defense, every law-abiding, responsible individual citizen has a constitutionally protected right to keep and bear firearms commonly owned and kept for lawful purposes. In early America and today, the Second Amendment right to self-preservation permits a citizen to, quote, repel force by force when the intervention of society in his behalf may be too late to prevent that injury." That's according to Heller. Then, as now, the Second Amendment may be considered as a true palladium of liberty. Unfortunately, governments tend to restrict the right of self-defense. In most governments, it has been the study of rulers to confine the right within the narrowest limits possible. Fortunately, no legislature has the constitutional authority to dictate to a good citizen that he or she may not acquire a modern and popular gun for self-defense. Even while claiming that citizens have a constitutionally protected right to keep and bear arms, Judge Benitez must place limitations not included in the Constitution of the United States. For this reason, Judge Benitez's words ring somewhat hollow. While noting that the right of self-preservation permits citizens to repel force by force, he limits that force to arms commonly held by citizens. Thereby, he leaves the law-abiding citizen woefully behind in an arms race against the very criminals, tyrants, and terrorists from which he says we need to protect ourselves. Even when claiming we have the right to use force to repel force, it appears he believes that is only until the cavalry of society rides over the hill. What is the law-abiding citizen to do if that cavalry does not come? Sadly, while Judge Benitez claims that no legislature has a constitutional authority to dictate to a good citizen that he or she cannot acquire a modern rifle, he still qualifies it to those guns that are popular. Judge Benitez finishes his conclusion with this, quote, "The court does not lightly enjoin a state statute. However, while the court is mindful that government has a legitimate interest in protecting the public from gun violence, it is equally mindful that the Constitution remains a shield from the tyranny of the majority. As Senator Edward Kennedy said, quote, the judiciary is and is often the only protector of individual rights that are at the heart of our democracy, close quote. Law-abiding citizens are imbued with the unalienable right to keep and bear modern firearms. I only wish that Judge Benitez and all other judges could both quote and apply the Constitution of the United States without the limitation of qualifiers. If the Constitution is a shield from the tyranny of the majority, why does Judge Benitez claim the Second Amendment only applies to popular firearms? If he believes that Senator Kennedy was right that the judiciary is the protector of individual rights, why does he leave them open to the judgment of justices rather than the consent of the people as expressed in the Constitution of the United States? Good news and bad news indeed. I'm happy. I am very happy that this judge has recognized that California's assault weapons ban is unconstitutional. I wish he had built it on better foundations, but this is the house that we have. As I said, this has already been appealed to the Ninth Circuit Court of Appeals. I'm not holding my breath for a constitutionally based outcome, but you never know. And regardless of the Ninth Circuit's opinion, I expect this to go to the Supreme Court. The question is, will the court accept it? See, all around this, what do we see? We see the Constitution made subject to the opinion of judges, to the whim and will of high priests in black robes. Now, again, I'm happy that Judge Benitez got to the conclusion he did, but by anchoring it on the opinion of judges rather than on the supreme law of the land, it's a barge adrift at sea. So for those of you in California, I'm happy for you, and I hope this goes farther, not just through the Ninth Circuit. I'd love to see the Supreme Court pick it up. I only wish they would base it on the Constitution, not on their opinions. If you found this analysis of this opinion useful, helpful, educational, then please do me a favor. Go to the website, constitutionstudy.com, find the article, find the video, and the podcast, the audio as well, and share it with friends and family. In fact, if you're listening to this on podcast, I am on pretty much all your podcast platforms. I'm on Apple and Spotify and Google Play. Please subscribe to this. It helps boost my numbers. And if you're on Apple Podcasts, leave me a rating and review. Again, it helps other people find this. That's really the one ask I have for you, is to share and help me share this information. I think it's that critical. Now, if you'd like to do more, again, the website is there, constitutionstudy.com. You can ask a question. You can ask me to speak to your group. You can donate to the cause. You can help defer the cost of putting on these videos, of hosting the website, of all the work that goes in to putting this stuff together. And I would greatly appreciate it if you did. But I've also got a site you might be interested in. It's called the Constitution Scholars, plural. All right, scholars.com. Constitutionscholars.com. Right now, from Memorial Day to Independence Day, 2021, if you sign up, it's a free registration. Just go there, very simple, name, email address. You'll get an activation link, click it. All right. If you sign up for the Constitution Scholars, I will give you a $5 coupon off the store. Right? again, from Memorial Day to Independence Day. Also, if you post on the Scholars, I'm going to be giving away a book. So if you sign up, there's a raffle for one book. If you post, I've got a raffle for another book, because I want to encourage people to be engaged, to not simply, sign up, get their coupon, and then ignore it. I want you to be involved. I want you to ask questions, answer questions, be involved in the discussion, be involved in the debate. And Thomas Jefferson said that if we think the people of the United States are not prepared to exercise their power properly, the solution is not to take it from them, but to educate them. And that's what we're trying to do here. So check that out, constitutionscholars.com. I'm doing a tour this summer. Right now, I've got several states through the Northern Plains. I'm looking for more. So if you head to constitutionstudy.com/tour, you can find out about the tour. You can see where I'm going to be speaking. If you're anywhere near there and can join us, please, I'd love to shake your hand. I'd love to meet you face to face. Tell me that you've watched the video or listened to the podcast. I'm looking forward to meeting people. But if I'm not coming near you, and you would like me to, there's a form at the bottom of the page you can fill out and request that I come to do some event in your area. I'm looking for locations. I'm very much looking for locations. So if you think even maybe possibly fill it out, I'll set up a Zoom call. We'll discuss it and see what we can work out. That's all at constitutionstudy.com/tour. And if one video a week of the Constitution is not enough for you, well, I have a 5-day-a-week radio program on the America Out Loud Network and on iHeartRadio. Just go to americaoutloud.com and look for The Constitution Study, and you can follow me there. I'm on 4 p.m. Eastern Time, 5 days a week. Again, you can also find me on the America Out Loud app or on the iHeartRadio network by looking for the America Out Loud Network. All this I do to spread the word, to get that information out there so that the American people can better understand their rights, how they can use them and protect them and do so legally and legitimately. Hopefully you found that useful. Hopefully you found this interesting. And hopefully you'll join me next time on the Constitution Study.